Good morning and welcome to the 35th and final meeting of the Criminal Justice Committee in 2025. We've no apologies this morning and we're expecting to be joined later on in the meeting by Pam Goso MSP. So before we begin, can I first of all thank Kirsty Deacon from SPICE for all the help that she has offered the committee over the last few years. Kirsty is moving on, and I just want to say a big thank you to Kirsty for the support that she's given members throughout her time on committee, and we wish you well, Kirsty, in your new role. So our first item of business today is an oral evidence-taking session on a legislative consent memorandum number 67 for the UK Government's sentencing bill. So I welcome to the meeting Angela Constance, Cabinet Secretary for Justice and Home Affairs, Kevin Fulton, Community Justice Division, and Ruth Swanson, Solicitor, Legal Directorate at the Scottish Government. And I refer members to paper 1. So can I invite the Cabinet Secretary to make some opening remarks on the LCM? Cabinet Secretary.
Thank you, Convener. Good morning to committee. I'm grateful for the opportunity to discuss the legislative consent motion for the amendments tabled as part of the UK Government sentencing bill. And I also thank the committee and Parliament for their cooperation in expediting this work so that Parliament's view can be expressed before the final stages of the UK's bill's progress in early January. The UK Government introduced their sentencing bill on 2nd September this year to take forward recommendations that were set out in the Independent Sentencing Review led by the Right Honourable David Gauke, which was published October 2024. The UK sentencing bill intends to make significant changes to the sentencing framework and the management of offenders in the criminal justice system in England and Wales. This includes making changes to the sentencing of lower-level offences, release provisions for some prisoners, community order requirements and restrictions available for post-prison supervision. The areas of law covered by the sentencing bill are largely reserved, or else the provisions extend to England and Wales only. However, on the 14th of October this year, during the bill's progress, the UK Government tabled amendments which seek to extend the sentencing and release arrangements which currently apply to individuals sentenced for terrorist offences to those individuals sentenced for a national security offence. This means that all such prisoners will be considered for parole after serving 2/3 of their sentence, rather than those serving short sentences being subject to automatic early release after 40% of their sentence or 50% of their sentence, or those serving long sentences being first considered for parole at halfway through their sentence, as would otherwise be the case. As a result of this, several consequential and technical amendments are required to ensure that these provisions could also operate as intended in Scotland. The legislative consent of the Scottish Parliament is required in relation to these amendments as we consider that the changes being proposed would alter the executive competence of Scottish ministers in relation to their functions concerning release of prisoners of this type. Operationally, both the Parole Board for Scotland and the Scottish Prison Service have confirmed that these changes will have little to no impact, as there are no individuals held in Scottish prisons under a national security offence. The legislative consent of the Scottish Parliament is essential to ensure consistency between Scotland and the rest of the UK with regard to the sentencing of national security offences. Reflecting on these changes in Scotland will also ensure that Scotland could not be seen as a more attractive location for state threat actors compared with England and Wales. So I would urge the committee and the Parliament to support the legislative consent motion.
Thank you very much indeed, Cabinet Secretary. So can I open up and invite any questions from members on the LCM? Any questions at all? No? Okay, thank you. Would any member like to make any comments on the LCM before we move to the question of consent? No? Okay, thank you very much. In that case, is the committee content to recommend to the Parliament that consent should be given for the relevant provisions covered by LCM S6 number 67? Are we all agreed? Agreed. Thank you very much. And are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the LCM? Thank you very much. Okay, so thank you very much, Cabinet Secretary, for attending, and we'll suspend briefly to allow a changeover of witnesses. Thank you, Cabinet Secretary. Okay, thank you, members. So our next item of business today is evidence taking on the Prevention of Domestic Abuse Scotland Bill. So we have one panel of witnesses today, and I intend to allow up to 90 minutes for this panel. So I refer members to papers 2 and 3, and I welcome to the meeting Siobhan Brown, Minister for Victims and Community Safety, Jeff Gibbons, Violence Against Women and Girls Unit, and Graham Robertson, Public Protection Unit with the Scottish Government. So you're very welcome and thank you for joining us. So just before we start, I remind everyone to be as succinct as you can in questions and responses. So can I firstly invite the Minister to make a short opening statement? Minister.
Good morning, and thank you, Convener. Good morning, Committee. First of all, I'd like to start by acknowledging Pam Gossell's aim of tackling the horrendous crime of domestic abuse, one I think that we all share. Whilst violent crime is down significantly over the past 20 years, I am of course concerned about rises in incidents of domestic abuse, though acknowledge this will reflect increased confidence in reporting and due to new crimes brought in through the 2018 Domestic Abuse Act. I also welcome that convictions have increased with recent statistics demonstrating that Police Scotland have been able to proactively use these offence powers, which further increase public confidence in reporting domestic abuse. Tackling domestic abuse remains a focus of the Government, and we will always consider actions that can just do that. However, as we have said in correspondence and as the committee has heard in evidence sessions, we're not sure that this bill will reach its aims. On the specific proposals within the bill, we still do not have a clear understanding about how they will interact with existing processes and procedures, and this is a particular concern in relation to Part 1 of the bill. The committee is aware that those with domestic abuse convictions can already be managed under the multi-agency public protection arrangements known as MAPA and the Disclosure Scheme for Domestic Abuse Scotland, which allows individuals to obtain information and make an informed decision about their situation when they may be at risk in a relationship. Without a clearer understanding of interactions with these existing programs, the risk of duplication, competing demands on resources and associated inefficiencies and confusion is high. While the concept of a domestic abuse register seems to have been withdrawn, the bill does introduce notification requirements, with the suggestion that being on a list of some description would be a de-incentive to offending. As stakeholders have noted, and we would agree, that assertion remains unevidenced and consequently it remains unclear what, if any, added value this proposal would deliver. In relation to Part 2, the Scottish Government is already investing in the valuable rehabilitation work through the Caledonian system, which uses an integrated whole-family approach to address domestic abuse of women by men in Scotland. It is important to recognise that the Caledonian Men's Programme is a court-ordered programme, and it does not require legislation to expand the programme. Convener, turning to Part 3, whilst the Scottish Government recognises that more could be done regarding data collecting and reporting, we also consider that this can be achieved without placing statutory duties on Police Scotland, the Crown Office and Procurator Fiscal Service and charities to request and record data from victims. And I have noted the concerns from charities and how this would be onerous for them. On Part 4, as drafted, the bill would contradict the discretionary and the non-statutory approach to the curriculum currently in place in Scotland. Further than that, we have significant concerns in relation to how the establishment of duties on education authorities around the promotion, facilitation and support of domestic abuse education would operate in practice, and that does remain unclear. In conclusion, Convener, as we have consistently outlined, the Scottish Government remains committed to tackling domestic abuse to ensure that those who perpetrate violence and abuse, and the majority of whom are men, change their actions and their behaviour. And we are taking forward a range of actions in this area. We recognise that there is more that can be done, but we do not see the provisions within this bill as the most effective focus for the reasons outlined above. There is significant administrative impact and cost involved in the bill, and many of the proposals in the bill as drafted are not clear or defined, and it's not clear what the bill would additionally provide. So this leads me to the conclusion that the bill does not reach the right balance in the outcomes it aims to achieve, paired with the cost to public bodies and charities, and the Scottish Government cannot support it as it is currently drafted. I'm happy to take questions, Convener.
Okay, thank you very much, Minister, for your statement. And I think you've comprehensively set out some of the views that you have on the various parts of the bill. I wonder if I can come back to part one of the bill, the notification requirements and monitoring under MAPA. And obviously in Scotland we already have a well-established multi-agency risk management approach to domestic abuse that includes processes such as MARAC, MATAC. I wonder if you could maybe just outline whether or not the bill would improve the existing risk management approach that we already have, and specifically, do the provisions in the bill improve, would the provisions improve or add to the current approach? So what benefit might the provisions of the bill bring to the existing approach?
Thank you, Convener. I think what I might do is I might maybe go into a little bit more detail about what is currently involved and how we do not see, or we're not convinced how this bill would be integrated into the current system, if that's all right. So I've got quite a bit of detail to go through, but it might be helpful for the committee. So while I know the approach had moved away in the bill from defining the approach as a register, it would in fact deliver the same product, and it remains unclear how the proposals would work in practice, including the perceived interaction with existing schemes such as MAPA or DISDAS, and the operational and the financial challenges this presents, particularly to Police Scotland, that's been highlighted. And it's not clear to us or stakeholders like Police Scotland what benefit being on the register brings. There is not a clear case for incurring the significant administrative impact and cost, including opportunity cost, in managing a cohort in this way. The proposed approach, if the register brings people under MAPA, may be at odds with Scotland's aspiration for MAPA to be led less by offence category and more led by assessed risk. Now, the adverse police resource impact from policing an offence type instead of a risk, and this was a key finding in the independent review of the police-led sex offender management from the Creedon report. Those with domestic abuse convictions can already be managed under MAPA as an other risk of harm individual based on level of risk. And the bill suggests creation of a domestic abuse register. It is assumed that this would be creating a new IT system from scratch, which would be undesirable in terms of duplication and also affordability. Therefore, the most likely way of putting this into effect would be amending the system currently used for recording details of sexual and violent offending that justice partners can currently access, which is a VISA system. And the current VISA Dangerous Persons database is a Home Office system that operates UK-wide, so it's not solely in the gift of the Scottish Government to amend it to make the scale of change suggested here, and those changes, of course, would incur a cost. There's already Scottish systems such as the Central LSCMI system, which is a comprehensive general offending assessment and management planning method that can produce an overview of the risks and needs of all those going through court, and there is work underway to explore linking this with the court outcomes. The collection of further data on domestic abuse victims can be achieved through non-legislative measures, and this also remains a matter for the individual to decide whether to provide this information. There is a lot of detail here, but just with the current system in place, we are not convinced at this stage, the way the bill is drafted, that it would add value to this.
Thank you for that. Can I just go back to part of your earlier answer to that question? So I think what you said was that in terms of domestic abuse offences, am I right in saying that higher tariff offences or higher tariff offenders could possibly come into the MAPA process? Is that correct?
So yes, it says it says the proposed approach, if the register brings people under MAPA, may be at odds with the Scotland's aspiration for MAPA to be led by offence instead of risk.
Yeah. That's helpful clarification. Okay, thank you. I'm going to open up now to members, and I'm going to bring in Liam Kerr and then Sharon Dowie.
Thank you, Kavina. Good morning, Minister. Going back to your opening remarks, you said that this bill won't achieve what it's intending to, and that it lacks an evidence base, to at least relation to Part 1. But I'm sure the Minister will acknowledge that many individual respondents to this committee's call for views feel let down by the current justice system and feel unsafe. Minister, do you think that these provisions in Part 1 might go at least some way to both preventing or reducing incidences of domestic abuse and make victims feel safer? And if not, what is the Scottish Government doing as an alternative?
Yes, I thank the member for that question. At this stage, I do not believe that they will make the victims feel safer. There is a range of things that are happening in the justice system which the members will be acutely aware of legislation reform with the Victim Justice and Witnesses Reform Bill, my regulation of legal services, and also updating the victim notification scheme. So there is a lot of ongoing work happening at the moment throughout the justice system. I don't know if any of my officials would like to add anything more specific to that question. Jeff?
Yeah, we obviously looked at the evidence base for the idea of a register, and you'll be aware of the work from the University of Essex. And indeed, this was initially an idea that was proposed by the previous UK government to look at the idea of a register. The evidence suggests there's huge doubts about whether it would deliver its intent, which is as a disincentive to offending. And that's one of the areas when in discussion with stakeholders and groups, and I think you've had that from your evidence sessions, we haven't had any of those groups saying that they feel this is the appropriate intervention. Indeed, they've been more looking at how we can enhance and improve existing service provision, which is where, as the Minister outlined, we've been focused. So, for example, when looking at DISDAS and the power to tell and right to ask, how we can expand that further, how we can increase potentially the use of third sector organisations to increase the use of power to tell, to look at the data that's within that scheme, and widening public awareness as one aspect we're looking at, and obviously also the other aspect is increasing access to data in this particular area. So there's wider work going, but the actual premise of the register as enhancing or adding additionality isn't evidence in our view, and is indeed something we've discussed across with stakeholders and with other devolved administrations, the UK government, as an option.
I'm grateful, Minister. I'll come back to you, but I suspect just on something that Jeff Givens has just said, because you both spoke there and spoke earlier about the disclosure scheme for Domestic Abuse Scotland, DISDAS. In your letter, Minister, you talked about a workshop held in September to recognise that that scheme's been in place for a decade now. And you were looking at what more could enhance its operation further. To reassure the committee then, could you just give us a more detailed update on that and any work that you've got planned in relation to this disclosure scheme, given that we've received specific evidence that there's a lack of awareness of that scheme?
Of course. So in October, officials met with justice partners and key stakeholders to recognise the 10 years of DISDAS has been operational and to reflect on how it has operated, to gain feedback from support organisation with consideration on how to build on its success. And the key outcomes from those discussions from the meeting back in October included agreement for the group to meet again in the new year to look at specifically how to widen awareness of the scheme, and particularly among seldom heard groups under the power to tell aspect, aspects of the scheme, and other considerations also include further discussions on the role of the third sector organisations that support the disclosure process. So there is meetings ongoing to see how improvements can be made. I don't know, Jeff, if you've got any further, because Jeff is involved in these meetings.
Yeah, I mean, the group's met once. We're planning to meet again as part of the Police Scotland Domestic Abuse Forum, so it's about integrating the various groups as well, because there's quite a lot of those. But yes, I think it was acknowledged by Police Scotland that even 10 years on, and even the branding of DISDAS as opposed to Clare's Law, as it's more commonly known in England and Wales, is one of the areas we've talked about. Is that one of the reasons why it's not as recognised? Also, the data which we provided in the Minister providing a letter to committee, Police Scotland are not very good or not very regular in promoting the data around usage, which I think is quite important, but also recognising some of the challenges that have been raised around the scheme, true or otherwise, and addressing some of those. So there has been some feedback, for example, from victims around the process online has not been as straightforward as they thought, and it's making sure there's a mechanism for that to be fed back. And as I said, the other two elements which are key of the next meeting we have in January will be around seldom heard groups and looking at that. The data is quite critical. We don't really have a good grounding of who's accessing the scheme, where there might be challenges, so we need to look at that, and that's one of the focus with Police Scotland going forward. And as I said, also the other element, because the power to tell element is always challenging for Police Scotland to do for different reasons. I think they outlined that during evidence, whether there's a role for a third party in that to try to make that more available and something that could be easier to progress. So there's areas of that, but I think the key part of the discussion was an acknowledgement we need to do more to highlight, as the stats say, the use of the scheme is significant.
Yes, I understand. Final question, Minister. Some domestic abuse organisations, and indeed the member in charge of the bill, have said the notification requirements could act as a deterrent to domestic abuse offenders. To be fair, the Crown Office and Police Scotland have said they haven't seen an evidence base for that. But it's quite crucial for the committee to understand, Minister. What are your views on this? And do you think that there's a read across from the deterrent value of the sex offenders register?
So I think, and I have watched all the evidence sessions, that this is untested ground. So there's no jurisdiction that has this data. So it's hard to sort of confirm if this would be a deterrent or not. I don't believe we should be moving forward with legislation being a deterrent. In principle, I think if we're putting forward legislation, it has to be deliverable, affordable, and not just put in place as a deterrent. I know that there were concerns placed by the Law Society as well about the incentive to plead guilty may go to the perpetrator if they know that they might go on a register, and also highlighted perhaps manipulative offenders that might, for example, change their name as well. So there hasn't been any strong evidence that I've heard of or that I've watched in the committee that this would be a deterrent. So I hope that answers your question.
I'm very grateful. Convener.
Sharon Dowie, followed by Pauline McNeill.
So the bill as drafted proposes to introduce notification requirements for domestic abuse offenders convicted to at least 12 months imprisonment in solemn proceedings. And we've heard, the committee knows that there are existing frameworks in place such as MAPA, whereby some domestic abuse offenders will already be subject to notification requirements. However, this bill aims to fix gaps in the existing frameworks which have been identified. So could this notification system, specifically for the most dangerous offences, make a difference in cases and catch individuals who fall through the gaps of existing systems?
So from the evidence that I have heard, I do not believe that it can. As you know, we've got MERIT, which is a multi-agency risk assessment conference which focuses on the safeguarding of the high-risk victims by creating safety plans. We've got MATAC, which is a multi-agency tasking coordination, which focuses on identifying and managing serial perpetrators to prevent them from re-offending. We've got DISDAS, which is a disclosure scheme that we touched on in earlier questions as well. And also we've got the DAPOS, which is a domestic abuse protection orders. So I think what's not clear to us as a government is how that would fit in with the current processes and how it would work in practice, which is our concern.
Right, so we also received evidence from Cox which raised a concern that it's currently unclear what proportion of domestic abuse offenders are subject to MAPA notification requirements. So we already know that some are under MAPA as it is, but it's unclear how many domestic abuse offenders are subject to MAPA. So are there issues with data collection and monitoring this, and do you believe that if work on data collection with the current systems are improved, there would be less concern around the notification scheme for this bill, as we would have a better idea of how many people are under MAPA? And also, can you tell us how many people for domestic abuse offences are currently being monitored by MAPA?
I do have stats for domestic abuse. I don't have that specific unless my officials do, but I'm happy to write back to the committee on that specific point. I think data collection has been an issue that has been raised in the evidence sessions that I'm acutely aware of, and I think that there needs to be improvements there. There is a data improvement that's been a clear focus of the Domestic Abuse Justice Partners Roundtable, and work to date has included reviewing and mapping domestic abuse related data held by justice partners with particular reference to data on protected characteristics. And I know that the group is currently progressing a working paper which will draw together the findings of the data mapping exercise, including identifying data gaps and what opportunities there might be for data improvement. So I do agree that we do need to improve data, but there is work ongoing there. I don't know if any of my officials have. Graham might have more stats for you.
So there's about 8,300 individuals managed under MAPA currently, and sex offenders make up the majority of those, about 95%. There will be overlap between people with sexual offending and domestic violence offending. There will be all kinds of other offending types in there. There was about 63,867 instances of domestic abuse in 2023-2024. So I think that probably illustrates the point we're trying to make about bringing this cohort in their entirety as to what that would mean in terms of the scale of management under MAPA. So the Minister mentioned MAPA being risk-led, so people with domestic violence convictions can be brought under where the risk warrants that level of management. Bringing them in as an entire group would potentially significantly increase the number of people managed under MAPA, such that the concern of our stakeholders is you are administering a large group where the risk doesn't warrant it.
And then sort of you get a specific figure to tell us how many domestic abuse offenders are actually under MAPA?
We don't have that figure, no.
You don't? So that would need, we would need an improvement in the data collection for that?
It depends what your aim is. If you're trying to understand where all of those with domestic violence convictions are in the system, we would have information on that through the LSCMI system, so that would inform court reports. So that is informing the processes by which the system is managing those individuals. That's obviously not a publicly available register, but that information will be known to the justice partners.
Right. And if we only bring it in for the most serious of offenders, and it sounds like we're already monitoring domestic abuse offenders, the most serious ones on MAPA anyway, what would be the problem with this bill coming in? Why would we not want to go and look at the top? I think it was last week Dr Forbes had said the top 2 to 3%. So what would be the problem of using the current systems if we brought this in?
I think the current system allows individuals to be brought under MAPA. I think we're trying to work out what this would give you additionally beyond assessing people's risk and working out if they're to be brought under multi-agency management.
Okay, and just the last question. Police Scotland had said that they were a bit concerned about it being too bureaucratic, but if we tightened up on the offenders that were going to be included in it, do you think the notification system is sufficiently aligned? If it was sufficiently aligned with the existing systems such as MAPA, that the concern around bureaucracy could be addressed?
Can I just come in there?
Yeah.
I probably might bring Graham in for more detail, but one of the concerns I think that are raised in the first question was how it's going to integrate in the systems, and if there was, like, for example, a new IT system for the notification scheme. As I said, this would be done by the Home Office. It's not in the Scottish Government's power to do that, so it's quite complex, and it wouldn't just be a simple process. And I think that's one of the one of our concerns. It's not clear exactly how it's going to sit in with current processes.
So is that something that you would be able to work with the member on then? Because what I'm trying to get at is we've said it's complicated, and I know it will be. And I know that my colleague Pauline McNeill's going to ask some more questions about risk. But if we tightened it up and we're already monitoring some domestic abuse offenders through MAPA, then why can we not use the current system?
Yeah, I was going to repeat. So I'm still not quite sure what this is giving you beyond what the current system offers, beyond the kind of working through what people's risk levels are and then bringing them under MAPA if they've got violent convictions, domestic violence convictions. The aim that the Minister's talking about there is that if you bring offence types in, you're treating one big group in the same way rather than, you know, dedicating the valuable resources of police, prisons, health, local authorities, those that work under MAPA, to focus on the people that collectively we think are the riskiest.
I know there are questions coming up in risk, so I'll leave it at that just now. Thanks.
Much. Pauline McNeill, followed by Jamie Hepburn.
Good morning. Yeah, so Sharon Dow had questioned, this is my area of interest at the moment. So we've heard quite a lot about the long register, if you like, in the bill. And so I understand all these points. But I think what Sharon Dow is really getting at, which is for the most serious domestic offences, you'd have to assume that sentencing reflects some level of seriousness. Could we explore a shorter list, put it that way, of the more serious offences? That's what I want to explore. I think I know what you're going to say about this, but let me just develop the point first. So I'm trying to then understand who's covered by MAPA and the differences between MAPA and a register. This is where I'm going. So as my first question is, I don't know, Graham, maybe given you've already answered this. I think it's important for the committee to understand who's covered by MAPA that commits a domestic, not a sexual offence, but a domestic offence. I think it would be helpful to understand that. I know you can't give us the numbers.
Yeah, so automatic entry into MAPA is through virtue of your conviction, if it's sexual offending, if you're a restricted patient, or it's an other risk of harm category, and that is where risk assessment establishes a risk, and MAPA can choose to manage those individuals, and that can include all types of higher tariff offending, including domestic violence.
So at what point is that then done? Is that, so in a high-level domestic offence, they will have served a sentence. So it's on release that kicks in, that process?
Yeah, so the notification will be in advance of release, so the planning can start earlier. Yeah.
So who identifies then, not the sexual offenders, but the domestic offenders, domestic abuse offenders, that they might be covered by MAPA? Who decides that?
So while somebody's in prison, they will be collating all of the information about their risk and planning for release, and as part of that process, they will make a referral into MAPA.
And then MAPA will decide. Right? And so an offender who has committed a serious domestic abuse offence, then on release, there are monitoring arrangements then while they're out. It's under MAPA. Yeah.
Yeah.
And so therefore, are you saying there that that is the same purpose as a register? I know there's other problems with the register, but to put those offenders on a domestic abuse register, you're saying does it fulfil the same purpose or not?
So I think it's maybe a question, but what is the purpose of notification generally? So that offers the partners, principally Police Scotland, the opportunity to ask a number of set questions of people to capture data about the person. But it's a good question because I suppose that's at the heart, trying to establish where the added value from this comes. They collect the information at the point of notification, but that is additional to a really rich amount of information that they will already have through risk assessment and triaging processes to do the active management of somebody.
Yeah, so that's why I think people are interested in the idea of a register with all the faults that we can see that it has, is that under the register there would be concrete legal requirements for the offender to say if they're going on holiday, if they are moving house. So you could see that just from a straightforward viewpoint, that it's the notification requirements that you might think might add something if you had a much shorter register of the most serious offenders. Because MAPA doesn't, or do you think, I suppose that's my question, does MAPA replicate that?
So, yeah, I mean, it will depend on the individual assessed risk and the management of that, but you could have a number of controls on people's behaviour. So, you know, you may have somebody already under licence conditions, you might have behavioural orders in place, other things will kind of be tailored to the risk level the person presents.
Thank you. Just lastly, I'm trying to just understand the process for all domestic abuse offenders on release. So there's the ones that you say could be identified. The other ones who are not identified to be in that risk category. What are the monitoring requirements, or what are the requirements on release? Are there any?
Again,
or is that just so variable?
Depending on the form of release. I mean, if it's a longer term prison sentence, most often people will be on licence with licence conditions tailored to the risk levels.
They're back in. Anything else?
Behavioural orders would be the kind of available suite. The police can manage somebody's a potentially dangerous person as well. And the information about their offending will also be known to the police, who can make, you know, public interest disclosures at any point if they feel that's warranted in a relationship.
So, Minister, just lastly, I wonder if you would consider then, so understand the range for MAPA, and then you've got variable conditions for those who are then released or not covered by MAPA. Might there be some advantage in looking at something else? Because then there's no way of tracking those offenders, or because it has to be quite serious to be covered by MAPA. Maybe there's something in between. Maybe a serial offender, for example, on release is not covered by MAPA. So there will be maybe bail conditions, not bail conditions, monitoring conditions. But what if there's not? Might there be a gap there?
So at the moment, and I know that the bill, and I think, so apologies for repeating, I'm not sure if I'm 100% understanding what you're asking for here, but if the bill is asking to create a domestic abuse register, so that we're assuming that would be a new IT system that would cause it, this is where I was talking about the Home Office being involved, and there'll be a lot of duplication. Are you asking for maybe it to try and be attached to the MAPA computer IT, which I don't know. Okay, so you would be wanting a new register and a new IT system specifically for domestic abuse, as in? No,
it's more a more sort of general question, which is this. I'll rephrase it. For those domestic abuse offenders, it's a solemn case, so we're talking about serious offenders who are not covered by MAPA. On release of prison, victims are worried about their safety. In fact, I've got a few cases at the moment, actually. We all have, right? But it's the notification requirements that the Sex Offenders Register, those the requirements might give victims some peace of mind that they have to notify the police. There's a more serious monitoring requirement. Now, I know there's lots of problems with that, but I'm just posing the question just for posing's sake. Maybe there is a gap.
It's something that could be considered. As I said, Scottish Government is open to considering anything that could be implementable and valuable. So it's something that could be considered in the future, if it could be integrated into the current system.
Yeah. Thank you very much.
Thank you. Jamie Hepburn, then Rona Mackay.
Thank you, Convener. And I've just got a few questions on the back of the memorandum that you very kindly sent us yesterday. Minister, the first relates to the financial memorandum and the assessment the government's undertaken in relation to that and the costs of the bill. Specifically, you set out that there are significant costs on local authorities been estimated at, I won't give out the precise number, but around 4.8 million under Part 2 and 4.8 million under Part 4. You say these are likely to be underestimates. So I suppose the first question is what leads you to conclude that to be the case if you have a figure you think is more realistic for that one specifically, but also just more generally in relation to the bill as a whole and its costs?
Yes, I thank the member for that question. I think the significant cost, I think it is estimated at 4,747,000, and then Part 2 is 4,800,000 in Part 4. And as these are likely to be underestimates at this stage, given from what we've spoken to stakeholders, and maybe Jeff, who's had these conversations, could maybe give some more insight into that.
Yeah, I think one of the unknowns is the extent to which the register as a concept sits in isolation for the other schemes. Is it new? How did it interact with existing schemes? That's not clear. So that, as we know, the technical challenges across different systems alone raise complications before you look into try to some kind of integration, which is clearly something we want to achieve, not least if that's going to improve the data collection. So there's lots of unknowns about where the scheme sits as a concept alongside existing schemes. Does it duplicate, does it replace, and therefore that makes it difficult to work out what the costs are likely to be. But if you are looking at integration with existing schemes, that will always add additional costs because of the unknowns around the technology, which is going to be quite key to address some of the concerns the committee has already raised about the evidence gaps and consistency. It also presents opportunities around that data as well, but I think that's the balance between a concept of something new as opposed to addressing perceived existing gaps within existing schemes, and that's a different way of looking at the issues.
Well, Part 2 is more to do with the rehabilitation work, and Part 4 is the education part, isn't it? So what have local authorities been saying in relation to the expectation around costs?
Very much around, I think initially the main focus has been about the aims of the bill and what it's trying to achieve and where that fits in. That's been our main focus, but concerns about cost, additional pressures on who looks after the register is one question, who accesses the register, the data protection issues around that, all of which cause concern about particular costs and I think general concern about existing pressure on service provision and adding that and additional costs and how that's met. So that's been part of that conversation going forward.
If I can just come in briefly, I think in my letter that I wrote to the committee yesterday as well is that the financial memorandum is the estimated cost for this bill annually is around 14 million to 19 million in 25 to 26 terms, and then up from 17 million to 23 million in year 5 costs, and these are likely to rise annually before. And as I said, as Minister wanting to put through legislation, I want to make sure it's affordable, that it is making a real impact, and at this stage the Scottish Government does not feel the bill as it is drafted is worth what is mentioned in the financial memorandum. Can I touch on the education point?
Feel free.
Yeah, just because I know that in Part 4, so as you know that we don't take a prescriptive approach to the curriculum in Scotland, and it's very much up to the individual schools and local authorities what approaches they use and external partnerships that they build to help them deliver relevant and engaging learning. The curriculum already includes learning and teaching about domestic abuse and places a requirement on Scottish ministers and education authorities that would also create a precedent. Curriculum for Excellence contains learning experiences and outcomes designed to ensure children and young people learn about abuse and power dynamics in relationships, and Education Scotland's website contains a section on domestic abuse information for educators, which includes links to various teaching resources. So it would be setting a precedent if we were to dictate specifically domestic abuse education in schools.
No, I take that point. Just going back to the memorandum, you said a couple of other areas I wanted to explore, and going back to Part 2 around rehabilitation, you talk about the commitment to expanding the Caledonian system more widely across Scotland. You set out some of the activity that's underway. I just wonder if you can expand on that. Is there I guess it's about the how and the when are the key things in relation to expanding that. So can you set out the work that's been undertaken and when you think that's more likely to be more widely available across Scotland. I mean, ideally it'd be available across the entirety of the country. I suppose that must be the aim. So
Yeah.
is that being worked towards, and when is that likely to
Absolutely. So the Scottish Government is committed to ensuring that perpetrators of domestic violence are held to account. And that's why we are proud to sponsor the Caledonian system, which works with men convicted of domestic abuse related offences to assist in reducing reoffending and offering integrated services to women and children. In 2025 to 2026, a total ring-fence budget allocation for 23 local authorities who operate the Caledonian system was just close to £4.5 million. And there was a further 1.4 million provided by the Scottish Government to local authorities this year. The Caledonian system is operated by local authority criminal justice social work departments, and the Scottish Government is committed to roll out the Caledonian system across Scotland. And at the moment, we've got 23 out of the 32 local authorities now delivering, and there's going to be a further 2 areas rolled out by the summer 2026. But this is an example of where we can roll out more support without legislation in place through the Caledonian.
So by summer, you're talking sort of, we're talking, so we're up to 25, so 7 local authorities left. You know, what's the impediment to going further, or is it just
I'd like to see all 32 local authorities.
Yeah, indeed. So,
yes.
What are they saying is the issue?
I might bring in, yes, Graham.
Yeah, well, I think a number are quite positive. So, yeah, that's up to 25, and there's a further 2 that are talking about starting at the latter part of 2026 as well. I think there's not a significant impediment for people. It's working at a pace that suits them for the rollout. With the additional money that was added into Caledonian this year, we've seen significant interest in moving to start to deliver. Some areas have got existing programmes that they're proposing to move away from. Some it's just scheduling the kind of training and the central support so that they're kind of ready to go. I think beyond that, there's some groupings on the islands where they have struggled, I think, to work out how they might configure services to deliver. But we're engaging with them specifically to have a discussion about whether there's any reasonable adaptations to the programme or anything we can do to take account of the challenges they have, which are often just smaller numbers, and the geography, meaning that kind of group works and things that are constituent parts of the programme maybe need a little bit of additional work to establish how they can best deliver for their areas.
Well, so that is quite significant progress by the end of next year, and there's confidence that we should be able to get that across the country in due course.
Yes.
Okay. One last area relates to part 3 and about data collection. You talk about and you already said this, about how you recognise more can be done in that regard, but you think it can be achieved without this legislative provision. And you talk about the concern of, I think you use the specific term, significant burden on charities who clearly not constituted. You know, it's one thing asking courts and the rest of Police Scotland who will be gathering data all the time. But what leads you to conclude that? Have charities been speaking with the government? Have they been raising these as a concern?
They may have, I'll bring in officials if they've raised specifically with officials. They have not with myself, but obviously I have been watching the evidence sessions online after your meetings. So, yeah, we recognise, and I know it has been raised, that there has to be an improvement in data collection, and this is where I think with Mrs Dowie that I mentioned the work that's ongoing with the Domestic Abuse Justice Partners Roundtable, for example, and looking how they can get a data mapping exercise, including identifying the gaps and opportunities there might be for data improvement. I don't know if any, Graham or Jeff, have any insight into conversations with charities that you might want to highlight to the committee?
Not specifically with charities, but part of the work of the Justice Partners Roundtable, which is very much the justice sector in terms of courts and police, Judicial Institute and Crown, is the current exercise we're doing to map the management information data that's collated, the non-public facing data, and what that tells us, and also what is in the public domain, to see where there are gaps and how we can then look to address that, where there's inconsistencies. The second part of the discussion, once we look at what's available within the government sphere, is what's available by third sector. Organisations clearly having more regular interaction with potential victims of incidents and how that factors into policy and operation development. So there's a two-stage approach that we're taking at the moment to how we improve the data collection. There is a recognition that data can always be improved, clearly. It's about why we're collecting the data, not just collecting it for the sake of it, how that's going to be applied. But I think the biggest gap we notice is the inconsistencies in how that data is aggregated in different organisations. So how do we manage that? So the roundtables has been ongoing for over a year to look at different areas, and this is one of the key focuses. So as the Minister outlined, next year we hope to have a paper which will clarify the position in terms of the justice agencies, and then the next step will be how we then have a conversation with third sector about how we gather that data, recognising we don't want to put a huge burden on those, but they are clearly collating far more than we currently have in different instances. So that's very much the focus.
So there'll be greater clarity next year in terms of the sort of next steps?
Absolutely, yeah. We're thinking more also around what more data we can put in the public domain, but equally want to make, but it has to have a clear purpose, which is obviously the importance of data. Data in itself isn't necessarily going to drive change. But
down here that this legislation could cut across that and divert away from the purpose of what the discussion's been thus far?
I think the question is always whether there's a need to legislate to gather data, or whether that's something that the organisations could be looking to doing. And often that it's seen if there's a failure to deliver that or collate that as a question mark. There is data already out there. It's about how we increase that. So I don't think you need to legislate for organisations to do that, because I think we all recognise the more data we have, the more we can be more effective in terms of the work we're doing and develop policy.
Okay, thanks.
Thank you. Rona Mackay.
Thank you. Good morning, Minister and panel. I want to ask you about Part 4 of the bill, which is about school education. And Minister, in your letter to the committee, you noted that there are issues with prescribing the content of education and legislation, and the respondents to the call for views highlighted the Equally Safe at School programme in relationships, sexual health and parenthood, etc. I'm just wondering if you could maybe expand on the ways that the Scottish Government could achieve the ways that this bill is attempting to do in other ways, just to address, the wider issues around gender inequality in schools.
Yes, thank you, and apologies, I sort of went into that question with education, with Mr Hepburn's questions as well. But the curriculum does currently include learning about domestic abuse, and that's why placing a requirement specifically for domestic abuse and other issues would set a precedent. And the Curriculum for Excellence contains learning experiences and outcomes designed to ensure children and young people learn about abuse and the power dynamics in the relationship. The Education Scotland's website contains a section on domestic abuse as well, and in addition, the Preventing and Responding to Gender-Based Violence, the Whole School Framework contains resources on domestic abuse to assist all school staff to support children and young people who experience domestic abuse. So there is work ongoing, but as I've said, we're always keen to see how we can do more, and happy to work with any members that have any ideas and how that can be improved.
Yeah, I mean, so I think from what you're saying, it's another example of a duplication of, the bill would bring in a duplication of work that's already been done. The other question was that the Crown Office had said that they were questioning the right of a parent to withdraw a child from domestic abuse education, and whether that's compliant with the UNCRC. And what's your view on that?
So Article 8, I think, is of the UNCRC is the right to education. I'm not a lawyer, so I can't answer that question because it's quite a complex question. I don't know if anyone's got any insight to if that would be in breach of UNCR.
Certainly, it's an issue that education colleagues are aware of. I think there's a couple of other areas where there's a potential opt-out already in existence, but I can't remember what they are exactly. It's something. It was more around the focus and the intent of the education, and then children being taken out of something, particularly where they may, of course, it may well be for other reasons. So that's something that will need to be
examined.
Yeah, it's something that clearly you need to be compliant with UNCRC, but then there's the broad implications about the target audience and not reaching them if they've been taken out for different reasons.
Thank you. That's fine. Thank you, Convener.
Very much. Fulton McGregor.
Good morning to Minister and officials. I've got a few questions that are kind of scattered about a wee bit, so bear with me. first couple, I'm going to put my old criminal justice social work hat on as well, and I wanted to ask about the use of community payback orders, and if you think there's more we can do with those in this area. Now, Social Work Scotland told the committee that an alternative to implementing notification requirements could be to include something in the community payback order. I mean, the community payback orders are designed to be quite broad. Do you think there's more use we could make of those in this situation to perhaps capture some of the aims of the bill here? And just if the government have thought about this.
Well, my understanding, and I'll be corrected if I'm wrong by my officials, is the courts at the moment do have the discretion for community paybacks, and also to further Caledonian, if that's suggested by the courts as well. I don't know, Graham, if you want to come in the protection side of things.
Yeah, so a programme requirement can be part of a community payback order at the moment, and you could get an intervention like Caledonian. But I'm not quite sure what was suggested by the witness, but sorry.
I've probably not asked the question very well, so I wasn't talking about specifically programmes like the Caledonia programme, which of course can be part of it. It was more about the an alternative to implementing notification requirements. So something that would almost mirror notification requirements being within a community payback order. You know, and they are broad, and I'm sure something like that could be put in, and perhaps some sheriffs are doing that. But if it's made, I think what Social Work Scotland are getting at when they spoke to the committee is if it's something that could be more, you know, more standardised and more regular, they think that that could actually be useful.
You can have conduct requirements as well within a community payback order. I mean, one of the activities that the government's already exploring that's kind of relevant to the community payback order is through changes to the LSCMI IT system. We're adding additional risk tools. So SARA, which is principally used to assess the risks of domestic abuse, will be held automatically in a central system. So all of the social workers who are making assessments for court reports will be completing that tool. All of that information will be able to be aggregated and reported upon. So there'll be very rich information about the cohort. So I mean, that might give you one of the elements that notification would otherwise give you. If it was like understanding of the numbers and nature of the cohort, that will be held in a central point.
Okay, thank you. And just to finish off that line of questioning, I know that as the chair of the cross-party group in social work, the Social Work Scotland will be keen to ask us. I wonder on that, the basis that we've spoke about there, if the Minister would be happy to meet with Social Work Scotland at some point.
Absolutely,
to discuss this.
Absolutely.
That's good. Moving on, I wanted to come in on the back of an area of questioning that Jamie Hepburn was going down, and that is around about the Caledonia project, which we spoke about there. Does the government have any data about where the Caledonia project has been used in relation to courts making decisions, as opposed to where they don't have it? Do they have any data there that's given courts confidence in areas where the Caledonia project is in place, as opposed to where it's yet to be in place?
Please, I don't have that detail with me at the moment. I don't know if any of my officials do.
So I mean, we know the areas where the programme is there, and we know when it's there, it's being used in high numbers. So we're seeing the numbers of programme requirements continuing to rise. So we take from that there is confidence in the approach. It's been accredited by the independent SAPOR body, so the design of the programme meets the highest standards. And some of the work I referred to is about getting really strong data for the purposes of evaluation for its next accreditation. So we know of the areas that are not delivering it. Some of them have alternative programmes in place. As we mentioned earlier, we are wanting to engage with those areas and find out what it is that they need or want, and whether Caledonian can help address those needs. But yeah, in answer to your question, I think we take confidence from the levels of usage that it's a measure that the courts are finding helpful.
That's good. That's a really positive answer. And finally, on Part 5 of the bill, states that the substantive provisions in the Act will come into force 2 months after the Act gains royal assent. Minister, what are your views on that timescale?
So that will come into force 2 months after?
2 months after royal assent. Have you got any views on that timescale?
I do not believe that's realistic. I think once we've got royal assent, as I said, legislation that goes through, we have to go through a budgetary process, make sure that we can afford it. So I think 2 months is very ambitious for a bill like this.
Okay, thank you. Yep.
Very much. We've still got a wee bit of time in hand. I wonder if I can maybe just come in with a question. It just goes back to your correspondence to the committee back in July, at the end of July, and it relates to the provision of information to the parole board around rehabilitative measures and support programmes. And I quote, the process could be strengthened, I think is what you outlined in your letter, but this wouldn't require legislation. So I'm just interested in whether this is something that the Scottish Government would be willing to sort of commit to looking at further, and are there other elements of the provisions in Part 2 of the bill that could also be achieved without recourse to legislation?
Yes, so thank you, Convener. I think one of the things that is us investing in the Caledonian system, for example, is one of the ways that we could be doing this without legislation, and that's, as I've mentioned, that we are looking to try and roll that out across Scotland, and we are making progress there. We're also watching with interest to see what the Sentencing and the Penal Policy Commission make any recommendations in the area of parole for next year when that comes out as well. So there is a range of things that we're doing at the moment, but also if there's any further recommendations, we're happy to take them on board as well.
Yeah. Okay, thank you. Just one final question from me, and it relates to training. So obviously when we introduce any new process, particularly around risk management and risk assessment, there's a level of training that's required for staff, police officers who are going to be using a new process. Now, I know this isn't specifically something that we've touched on to any great extent in relation to this bill, but I'm interested just generally, perhaps if you could maybe outline what sorts of training commitments and cost perhaps can be involved when a new process such as a risk management or notification process is introduced, particularly across more than one stakeholder or organisation.
Thank you, Convener. I don't know, as a protection, Graham, if you want to come in on that, because it's quite specific, and I think it would differ from each piece of legislation as well, what was being implemented, so it would be very variable. But
yeah, I mean, it's a very difficult question. It will very much depend what the nature of the change is. You know, there are changes that will affect a more general approach to risk management, where you could potentially tweak some of the central offering that's made around use of the LSCMI tool. If it's more specialist use of tools, again, there's offerings that Community Justice Scotland will offer to support staff through those types of training. If you're talking about a kind of whole system or type of change, you're going to be, you know, upskilling a whole social work workforce, prisons workforce, and others. So, yeah, it very much depends on the nature of the training, but generally big policy changes will require staff to be well trained.
Yeah, okay, thank you very much. Okay, if there are no more questions from committee members, I'll bring in Pam Gosel.
Good morning. Thank you, Convener, and good morning, committee, and good morning, Minister and officials. Minister, I'd like to ask a question around existing systems in place. Do you believe that Sex Offenders Register and the notification requirements imposed by it helps to keep the public safe?
I believe, in relation to your bill with domestic abuse, I think there is things that can be doing with sex offences, which is a different subject. But in relation to your bill, I think there are processes in place, and this is, and I know that the member is very passionate about this area, and it's unfortunate that we're not in a position to see how your recommendations of your bill can fit into this system that is put in place at the moment, but I am confident in domestic abuse that it is. Yep.
So, Minister, I asked the question around Sex Offenders Register and the notification requirements imposed by it. Does it help to keep the public safe, the Sex Offenders Register?
You should do, yes.
It should do, right. just on that obviously I know you've answered some of that. If you believe that the sex offenders, would be required to comply with the notification requirements, do you not believe that the same should apply to those guilty of crimes of domestic abuse?
I'm listening to the evidence from stakeholders, and I've not been approached by anybody in any of my meetings as well that have said this is something that will make a change and make people safer.
Okay. Minister, your letter says you agree with claims that notification requirements are unevidenced in terms of acting as a deterrent for potential offenders. So why is that system still in place for sex offenders?
Because it's been in place for quite a while now. So we're looking at domestic abuse specifically, not sex offenders. Today we are discussing your bill, which is about domestic abuse. It is untested. We've heard the evidence session. So this is why, at the moment, the suggestions in your bill do not fit in with what the Scottish Government are currently doing. But in saying that, and as I said, I know you're very passionate about this issue, I am very open and willing to work with you as a member on progress for the Caledonian data, anything moving forward. But at this time, it's unfortunate that we do not feel that we can support your bill.
No. Minister, just on a couple of questions on some of the other areas, data. Could you tell us which public bodies collect data on protected characteristics?
I'll bring in protection. Graham, he might be able to tell you that.
I would have to write you that information. I don't know off the top of my head which public bodies collect which.
You wouldn't know. My bill has been going on since 2022 and I've been talking about data since then. We are 3 years on and now, if I'm not wrong, I think one of the questions you responded to that you're looking at it next year, that will be 4 years on, Minister, that data is not collected. And I know, speaking to people of disability and coming from an ethnic minority background myself and speaking to those domestically abused, they're very worried that when they go into that police station to report that crime, that it's not even taken into consideration their background or sometimes a disability, that they can't even sometimes correspond in a way. And so this crucial data isn't even collected. We're talking about, you've just said, 4 years on. So why shouldn't this data be put in statute? Because 4 years on, the government hasn't done anything about it.
So there has been work, and I think I have raised this in earlier questions. So the data improvement has been a clear focus of the Domestic Abuse Justice Partners Roundtable, and there has been work to date, including reviewing and mapping domestic abuse-related data that is held by Justice Partners, with particular reference on the data on protected characteristics, which we will write to the member specifically on with her question about which public bodies are currently doing this. So there is work ongoing. The group is progressing with a working paper, and that's what will come out next year. So there is work ongoing with it.
Am I okay to ask? Am I okay to ask another couple of questions?
One more question.
Oh, one more, right, okay. On rehabilitation, you know, it's good to hear that you've said 23 out of 32 local authorities you've, rolled it out on, and it could be 25 on that as well. Now, obviously, Glenn Lloyd from Social Work Scotland told us last week that there is no consistency across the 32 local authorities. He also said that the Caledonian system is the only accredited programme in Scotland. Obviously, an election could change this, and a new government coming in May could decide that it's not worth rolling out the Caledonian across the country. If you agree that we could guarantee access to rehabilitation programmes, would it not be better to enshrine it in law that it's actually there, and it's not a postcode lottery for a lot of local authorities?
At the moment, you'll know where we are in the parliamentary term. That's not going to be done, and it also gives us a flexibility. And as Grant Robertson had said, there are issues in the island areas where setting up the Caledonian system, the Scottish Government is looking at how we support it. We do want to get it rolled out for the 32 local authorities. We're currently 23, it will be 25 next summer, and I think Graham said another 2 will be coming on next year. So this Scottish Government is committed to the Caledonian programme and keeping it rolled out to give the support to people with domestic abuse.
Kavina, I've just got one more, is that all right? Just one
final one.
Thank you, thank you. Are you satisfied that the Equally Safe Schools programme complies with the legislation such as the UNCRC at the moment?
Yes, I am.
So if you agree that there is nothing wrong with the Equally Safe at schools and there is, that it's compliant with the legislation like the UNCRC, why would there be a problem with the guaranteeing in law that this would be applying to domestic abuse education if it's available. So it's
my understanding is, even though Equally Safe is rolled out through COSLA and local authorities, it's not prescriptive for local authorities to take it up.
Thank you.
Okay, thank you very much. So that concludes our session this morning. Thank you very much, Minister and officials, for joining us. Appreciate your time. Can I just wish everybody a very happy festive season when it comes and a peaceful recess, and we'll now move into private session.